Good evening, everyone. It's my pleasure to welcome you today to today's panel discussion, Climate on Trial, Lessons from Milieudefensie versus Shell Case, hosted here at the Astor Institute. My name is Stephanie Trefus, and I have the honor of moderating this discussion today. I'm a researcher here at the Astor Institute, and in my research, I investigate the human rights obligations of businesses with regard to climate change, as well as the impact of international investment law on local communities. I'm also the academic coordinator of the Netherlands Network for Human Rights Research, and we're grateful to the network for its support in putting on this event today. I'll first give a very short introduction to the case, and then I'll introduce all the speakers before I hand over the floor to the panel. Just a reminder that this session is recorded and it will go up on the Astor Institute YouTube channel after the event. So we're here today to examine one of the most significant climate litigation cases in recent years, the case of Milieudefensie and Shell. In 2021, the District Court of The Hague delivered a landmark ruling ordering Shell to reduce its CO2 emissions by 45% by 2030. In its decision, the court found that although human rights apply between states and citizens, meaning that they cannot be directly invoked in relation to Shell, due to the fundamental interests of human rights and the value for society as a whole they embody, human rights may play a role in the relationship between Milieudefensie and Shell. Therefore, the court could factor in human rights in its interpretation of the unwritten standard of care that applies to Shell. The court considered the UN Guiding Principles of Business and Human Rights to be an authoritative and internationally endorsed soft law instrument that was suitable as a guideline for the interpretation of the unwritten standard of care. It further included the broad consensus represented by the Paris Agreement that achieving net zero requires collaboration between different actors, including corporations. This decision was hailed as groundbreaking, setting a precedent for corporate climate responsibility. However, in November 2024, the Hague Court of Appeal overturned the ruling. The Court of Appeal determined that Shell has an obligation to counter dangerous climate change. However, this does not mean that the civil court is able to establish that Shell should reduce its CO2 emissions by 45% or any other percentage. Although the case, as argued by Milieudefensie, was not successful, the court upheld that protection from dangerous climate change is a human right and that corporations have an obligation to limit CO2 emissions in order to counter dangerous climate change, even if this obligation is not laid down in public law regulations of the countries in which the company operates. We heard yesterday that Milieudefensie is appealing the case to the Supreme Court, and we'll hear more about that development shortly. While the Court of Appeal decision may be seen as a setback for climate activists, it provides crucial lessons about corporate obligations, legal strategies in climate litigation, and the evolving role of courts in addressing climate change. Tonight, we're here to discuss questions like, what are the implications of this ruling for future climate cases? How can companies be held accountable for their environmental impact? And what legal avenues remain open for climate action? To explore these critical issues, we're fortunate to have 4 speakers who have a deep academic and professional interest in climate litigation and corporate responsibility. We're grateful to be co-hosting this event with Seven, the new Climate Institute of the University of Amsterdam, bringing together the knowledge of all 7 faculties of the UvA. Seven deploys this UvA-wide knowledge to combat climate change and make vulnerable societies anywhere in the world more resilient. To contribute to the radical and transformative changes that are needed to achieve the agreed climate goals, Seven adopts a system perspective and an inter- and transdisciplinary working method, bringing together all the knowledge and expertise available within the UvA. Joining us from Seven is co-founder Andre Nolkamper, who has been dedicated to the international legal protection of oceans, freshwater, biodiversity, and climate systems for over 30 years. His scientific work focuses mainly on the complexity of problems such as climate change caused by a very large number of states, companies, and individuals. When such problems occur, who is responsible for solutions and who can be held accountable for damage to people, societies, and the earth? He initiated the foundation of Seven in 2024 to find answers to these questions, and more generally, to create the systemic transition needed to mitigate climate change by using the knowledge from all relevant disciplines. Andre chairs the Seven team and is a distinguished university professor of international law and sustainability. Thanks very much for being here today, Andre. As our second speaker, we have Sjaakje van Oosterhout, who is the senior team lead at Milieudefensie, also known as Friends of the Earth Netherlands. Sjaakje leads the team that works on the climate case against Shell, which we all know to be one of the world's largest oil and gas companies. This is a landmark lawsuit that aims to hold Shell accountable for its contribution to the climate crisis and force it to align its business model with the Paris Agreement. Jacques is responsible for leading the team as a spokesperson for the case and provides research and analysis for the court case. Jacques has almost a decade of experience in climate policy consulting and specializes in greenhouse gas accounting, analyzing climate plans, and strategic international advocacy. Thanks also for being here tonight, Jacques. Annelies Kauper is an assistant professor at the Molencroft Institute for Private Law and co-director of the master program Private Law at Utrecht University. Her research revolves around the interaction between international, European, and national law, with a focus on the interpretation and application of international law in domestic legal systems in the fields of national tort law and human rights law. Annelies is a member of the Utrecht Center for Accountability and Liability Law and the Netherlands Institute for Human Rights. She's also a member of the Netherlands expert group for the British Institute of International and Comparative Law in the project Global Perspectives on Corporate Climate Change Tactics. Joining us online is Chiara Macchi, who is an assistant professor of law and member of the Jean Monnet Center for Excellence for Corporate Sustainability and Human Rights Law at the Wageningen University Law Group. Chiara was a co-chair of the Business and Human Rights Working Group of the Netherlands Network for Human Rights Research, and is the author of the book Business, Human Rights and the Environment, The Evolving Agenda, published by our own T.M.C. Assa Press and Springer. She's published a case note in the review of European comparative and international environmental law on the district court's judgment in the Milieudefensie and Shell case, and is currently co-authoring a case note on the Court of Appeal's judgment. So the event will run as follows. Each of the four speakers will give a short presentation in the order that I just introduced them. And then I'll give the panel an opportunity to briefly respond to one another. Then I'll open the floor to questions from the audience. Those here in person can raise their hand to ask a question, and those online can submit questions in the chat. We'll wrap up at around 6:30, and there'll be a drinks reception for those attending in person. The event is being live streamed and will be recorded and uploaded to the Assa Institute's YouTube channel. So without further ado, I hand the floor to Andre.
I'll start again because now only the mic is on. So any case against any individual corporation for its contributions to climate change is important in itself because it may lead to a reduction of emissions of that particular individual corporation. But potentially, such cases can achieve much more. They can drive what I call systemic change. A case can force changes in corporate regulations and practices. It can help alter the investing decisions of investors. It can shift changes throughout the supply chain. It can push governmental regulations. It can change consumer practices and so on and so forth. So potentially, these cases are huge. And the big question is whether we know under what conditions, under what legal conditions, corporate litigation can actually achieve and contribute to these wider systemic changes. Now, these are huge questions, and in the 8 minutes that are allotted to me, I can just scratch the surface of this big topic, but I will do so in making 3 smaller reflections. Let me start by the first one. First point is that the systemic nature of climate change policies and practices does not preclude litigation against any individual corporation. So with the systemic nature, I mean that climate change is the result of the actions of a huge number of states, corporations, supply chains, and consumers. That systemic nature, of course, should inform litigation strategies of plaintiffs, like Milieudefensie, as plaintiffs always will need to determine whether targeting an individual corporation is wise or efficient, or whether efforts should be put at other parts of the system. Governments, states are focusing on demand rather than supply. But the two judgments in the Shell case have learned one important point, and that is that once a plaintiff, like Milieudefensie, has made the choice to litigate against an individual corporation, the systemic nature of the process in itself is not a legal defense for Shell or any other defendant. So the Court of Appeal has, following the Supreme Court in Uganda, rightly rejected the defense that Shell is only one player in a much wider system. That argument simply does not fly, and I think that's an important takeaway from the Court of Appeal's judgment. But the Court of Appeal did cast doubt on the one other crucial element of this wider system. So the Court of Appeal said that the responsibility of a corporation may be limited if any emission reductions simply would be compensated by higher emissions by other actors elsewhere in the system. So if Shell wouldn't sell oil, someone else will. The court said that it could then not be established that downsizing the sale activities of Shell will actually lead to a reduction of emissions. Now, that conclusion seems to me to be highly debatable. Assuming a corporation has an obligation to reduce emissions, I come back to that assumption in a second, the possibility of market substitution should not be a defense. So also here, the principle that each actor is responsible for performing its own obligations should be decisive. However, there's one important caveat that may well be on the table in the cassation on which we will hear more. So whether or not sales by other actors' system, so other oil companies, are relevant or not, will depend on the specific formulation of the claim by the plaintiff. If a plaintiff formulates a claim in terms of an overall emission reduction, the acts of other companies might well be relevant because after all, they contribute to the overall emission reduction. That may be different if the claim is formulated in terms of the production or sales by any specific company. I can imagine that Milieudefensie would want the Supreme Court to say more on this particular question. But the point does illustrate that in all cases, we will need to carefully analyze the complexities of the wider system in which an individual corporation is placed and its relationships to other actors in that field. This is my first point. The second point, this is the overriding importance of domestic national law in corporate litigation. So this may be a bit counterintuitive because the whole system of production, sale, supply, and consumption of fossil fuels transcends clearly national boundaries. This is a global affair which cries for transnational and international standards. Yet, if a claim is brought in any particular jurisdiction, the court necessarily will need to simplify that normative framework and bring it down to a particular domestic legal system. Now, on this point, too, the Court of Appeals was not very clear. It stated that it recognized that companies whose products contributed to the climate crisis and who have the power to act are obliged to act in relation to the global population. But the question is what that means in terms of law. Statements like this that refer to obligations or responsibilities only have legal significance in the context of a specific legal system. And discussing obligations to corporations without grounding them in any particular legal system is actually quite meaningless. The statement that corporations are obliged to act certainly is incorrect in terms of international law. The Paris Agreement is all over these cases, but when all is said and done, the conclusion has to be that corporations have no binding obligations under the Paris Agreement. States may and should include corporate obligations in their nationally determined contributions, but these are matters of domestic law. And I do believe that the Court of Appeal rightly said that the 45% reduction target, which stems from the COPs and the framework of the Paris Agreement, does not apply to individual corporations. So if the term duty or responsibility has any meaning in the Court of Appeal's judgment, it has to refer to domestic Dutch law. Now, in discussions about the Shell case on LinkedIn and elsewhere, there has been much discussion across boundaries because people all over the world are looking at this case, what they can take away from it. Rightly so, because this may be an inspiration. But it's my contention that in discussions about cases like Shell, there's a general underappreciation of the dominant importance of the specific domestic Dutch law in this case. A couple of very good analysis of the by now well over 2,000 climate change cases all over the world. And if you read those analyses, it's quite clear that a leading conclusion is that domestic law is totally decisive for the outcome of cases. So again, national cases like Shell may be an inspiration, but we should be very careful before transposing this to other jurisdictions which may have totally different rules on tort law and the interpretation of the tort law by public law. So in conclusion on this point, there's a fundamental tension between the global nature of the whole system that produces the climate change effects, between the global nature of the Paris Agreement on the one hand, and the localized nature of corporate litigation. And that brings me directly to my third and final point. This is the important and dominant role of public law in corporate litigation against Shell and other companies. Now, the court recognized in a decisive paragraph that companies that have contributed to climate change and that have the power to act are obliged to do so in relation to the global population, even, and I quote, even in the absence of explicit public law obligations, even in the absence of explicit public law obligations. Now, that certainly is true in theoretical terms, and at least as a matter of Dutch law, it is true in particular legal and factual context, and there's case law by the Supreme Court on this. But in relation to climate change, it is very hard to see how a court can identify a specific climate change obligation for corporations in tort law in the absence of an identifiable public law standards that the court can apply, whether grounded in domestic law, European Union law, or international law. And for comparison, the Urgenda case succeeded because in Urgenda, there was actually a clearly identifiable public law standard. And in the recent nitrogen judgment of the District Court of The Hague, there also was a clearly identifiable public law standard that was not complied with by the government. In the Shell case, for the Court of Appeals, these public law standards were much harder to find. As I noted, they clearly could not be found in the Paris Agreement. They also cannot be found in the otherwise totally important European Union's Corporate Sustainability Due Diligence Directive, which envisages transition plans by corporations, but these in themselves do not contain standards for reductions. So the court has had some very interesting language on possible obligations. So the Court of Appeal suggested that there may be obligations of Shell in relation to scope 3 emissions. So indirect emissions generated in the value chain of Shell, but produced eventually by consumers or other actors. However, the court did not articulate what this obligation actually was or could be, which may be informed in turn by the specific nature of the claim by Milieudefensie. And likewise, the court made very interesting observations on Shell investment in new oil and gas fields. It suggested that companies should consider the negative consequences of expanding fossil fuel supplies on the energy transition, and that failure to do so could be the basis of a claim. But also here, the court did not articulate whether such an obligation actually existed and on what basis it would actually find that obligation. And that is not so easy, because there are, at the international level, ongoing negotiations and discussions on the desirability of articulating a new prohibition on the expansion of oil and gas fields, but these are yet to be completed. So the question then is whether a court could, in the absence of agreement, formulate that rule. So my point is not, and I emphasize, is not that that separation of power concerns should preclude a court from making pronouncements in these cases, because clearly in Uganda and in nitrogen, the court rightly ordered the political branches to act, notwithstanding any concerns of separation of powers. But again, in those cases, there were public law standards. And the question is, that may be a good point for discussion, whether actually we can identify in this particular case public law standards that the court can use in relation to corporations. And that leads me to two takeaways on which I will conclude. So my first takeaway is that plaintiffs, Milieudefensie, but the point is true more generally, should be extremely careful in formulating their claims in tort cases in terms of obligations that can be grounded in public law standards. If such obligations cannot be identified, courts would do well to be very cautious, as the Court of Appeal actually did in the Shell case. And the second takeaway, which may, when I reread my notes, actually was my most important point. So my second takeaway is that any finding on the absence of liability of a corporation, because there's no standards, is an implicit directive for the government and the legislature to act. So leaving aside what will happen in cassation, for now, the decision of the Court of Appeals of The Hague should be read as an indirect condemnation of the state of the government of the state of the Netherlands, which until now has failed to adopt proper standards for the conduct of Shell. And the so-called maatwerkafspraken in Dutch, on which the government has been negotiating forever, are still going nowhere. And it is that failure to conclude these agreements and set clear standards for the industry that now came back to haunt the Court of Appeal in the Shell case. So another way, final sentence, another way of saying this is that the prospect for corporate climate litigation as a driver for systemic change will be much, much higher if the public authorities, the government, the parliament, do their job properly and translate the Paris Agreement in standards that are actionable in the courts. I'll leave it for this and take the other points in the discussion. Thank you.
Thanks very much, Andrew. I'm sure you've given Shakya a lot to so thank you.
Great. I have a couple of slides. It would be great if we can get them up. Hello, everyone. Nice to see you all. Yes, great. Yeah, I'm sure I can manage with this. Great to be here. My name is Sjoukje van Oosterhout. I've been working on the Shell case for about 5 years, so not entirely from the beginning, but for a while now. Yesterday was quite an important day for us because we decided to take the case to the Supreme Court. It's not a decision we took lightly. We spent quite some weeks debating on whether we should do it or not. And today I'll take you through the decision in 2021, what the court said in 2024, but I'll mainly focus on why we're going to the Supreme Court. Because I'm sure that's maybe the part that you haven't been reading about as much since it only happened yesterday. So yeah, what happened in 2021? I'm not gonna talk about it for too long because we've heard it already quite a few times, but the court established that Shell had a reduction obligation of 45% over scope 1, 2, and 3, responsibility of its own to respect human rights, responsibility of its own to prevent dangerous climate change, and very importantly, that responsibility is for the entire value chain, which was groundbreaking and made news all over the world. Then in November, the Court of Appeal actually upheld quite a few of those things. Shell still cannot hide behind states or consumers. It has a responsibility of its own to respect human rights, to prevent dangerous climate change, and also for scope 1, 2, and 3, which is very, very, very important. For Shell, about 95% of its emissions are in scope 3, so in the indirect emissions, so the emissions caused by their consumers. So it was crucial that the court said something on those scope 3 emissions. And these are very important findings that actually were upheld by the Court of Appeal by the ruling in November. Some other very important takeaways are that, as Andre already alluded to, those investments in new oil and gas fields may be at odds with the Paris Agreement. Also really highlighting the power and influence of fossil fuel companies and the special responsibility that they have to prevent dangerous climate change. Also saying some very important stuff on public regulation and that it doesn't indemnify. And very importantly, saying that fossil fuel producers or companies have a responsibility to reduce their supply regardless of demand. Also very important findings. Now, we were very happy with the ruling up until then, but then the last, I would say 20% didn't make us as happy because the court said that they couldn't quantify the reduction percentage, saying that there was no expert consensus on the matter. And then also on effectiveness and substitution, the court claimed that we didn't have interest because Shell could implement the emission reduction order in an ineffective way, saying that other companies might potentially take over Shell's sales of oil and gas. Yeah, we were not agreeing with that. So something went wrong with the letter type there. But basically what the court did was saying, yes, Shell has an obligation. So Shell has a duty to reduce its emission. But the court failed to provide accurate protection. And I loved this quote that I saw the other day in one of the independent commentaries on the case, saying by Dauma, saying that this is as if a company like other companies discharges a dangerous toxic substance into the water, but because a judge is unable to determine how much less poison the company should discharge, then simply does not impose any obligation at all, while simultaneously stipulating that the company should not be discharging the poison. This is how it feels to us. Shell has a duty to reduce its emissions, but the court failed to say exactly with how much, and therefore it's missing the teeth to actually make Shell, one of the biggest polluters in the world, act. So why did we go to the Supreme Court? 3 reasons. I'll go over them very quickly. First of all, we feel that the court has a duty to offer effective protection against dangerous climate change. As mentioned in the example before, if you discharge poison, then just because you can't exactly determine how much doesn't mean you shouldn't do anything at all. Also in the Klimasignorinen case, it became very clear that courts should intervene in case of imminent violation of human rights. Then I think this is also very important. The court claimed that there was no expert consensus on the reduction percentage. It's very important that the court should look not just at science, but also take legal principles into account. The court applied a standard in determining the percentage that was too narrow, for the topic that we're dealing with. The court should have also taken into account international treaties and soft law that is based on climate science, and more importantly, also should have taken into account international legal principles, such as the precautionary principle, the intergenerational justice principle, and the CBDR principle. This may seem a bit like odd, like if you haven't read the case fully, you're wondering like, why not just science? In the substantiating the court case, I think we handed over 16,000 pages, something like that. And of course, the Paris Agreement was very important, but we also showed a lot of other international standards and protocols, United Nations reports that are also saying and underlining the importance of halving emissions in 2030. Then in addition to that, we also showed a lot of sectoral pathways that say what the oil and gas industry should be doing. Now, we highlighted that if you put very important international legal principles on those sectoral pathways, then you also get to at least 45% emission reduction. For example, if you look at one of the sectoral pathways and you say that we take intergenerational justice into account, then it's not okay to take models that basically push the emission reduction further into the future. If you take the CBDR principle into account, then you also say companies based in the global north, companies that have historically emitted a lot, should take a bigger responsibility than companies or governments based in the global south. You also say that coal should be phased out not earlier than oil and gas, but because coal is primarily used in the global south. So if you take all of these into account, then looking at the percentages put forward in the court case, at least 45% is very reasonable. And lastly, on effectiveness and interest, the court basically said that we wouldn't have any interest because Shell could implement the emission reduction order in a way that wouldn't be effective via their trading business, and that other companies might take over the sale of oil and gas. First of all, it's a lawsuit against Shell, and Shell needs to cease its unlawful behavior. It's the so-called drug dealer defense, saying that if Shell wouldn't do it, then someone else would take it over. That doesn't make sense. Shell has their own responsibility to act. Secondly, the court shouldn't have looked at if there was maybe one way in which it might not be effective, but it should have looked at all the ways in which it would have been effective. And there are plenty of ways in which Shell could have done that. And then also we've highlighted a big chunk of evidence that the court did not take into account, in which we highlighted actually that it's not true that if other companies take over Shell's sales or Shell's production, that it would be a one-to-one substitution. Shell is one of the biggest oil and gas traders in the world, actually the biggest oil and gas trader in the world. If Shell would trade less, then it's unthinkable that that would not lead to emission reduction. They have logistics attached to that business. They have financial services attached to that business. It is extremely unlikely that that would not have any impact on emission reduction whatsoever. More importantly, Shell has quite a lot of unique skills and expertise, means that a lot of the more tricky sort of oil and gas fields to exploit are not as easily substituted by other oil and gas companies. And we've highlighted quite a number of expert statements that underline this, and the court failed to take these into account. So yeah, what's next? We launched yesterday. We're gonna talk to the Court of Appeal and Shell pretty soon on agreeing on a timeline for this, but we're expecting a ruling in 2026. Then we have also announced a court case against ING, one of the biggest financiers of the climate crisis in the Netherlands. We're currently drafting the summons for that case, and we feel that the findings of the Court of Appeal has given us very strong basis to continue with that case. Yeah, so very excited to see where that's going to go. We're launching pretty soon. And then we also have our eye on some other major polluters. We have a list of 30. Well, Shell and ING were one of the 30, so we have 28 left. And we keep a very close eye on their climate plans to see which one of them should be next. So I think I'll leave it at that. Probably plenty of room for discussion later.
Thanks very much. Annelies, the floor is yours.
Thank you, and great being here. I also have some slides. Do I just press on? Yeah, so I'm, well, changing the subject a bit. I'm talking about climate change litigation against corporations as drivers for legislative change. Also only scratching the surface, but I hope to give a positive outtake on the whole, well, experience of going to court in these type of cases. And to start with a positive note, we first talk about the influence of litigation or regulation. We will discuss the first and second waves of climate change litigation, then go on to, well, see what aspects we can find in Milieudefensie versus Shell. And what's next, remedies, well, I'll touch it, but it's, we can discuss it further later on. Litigation can influence regulatory policy making. Indirectly, because there's a causal link is hard to establish. But if we are looking back at cases, which Timothy Litton did in his article, cases that were hot in the 80s, the 90s, like the gun industry, regulating the gun industry, some effects can be distilled from litigation. Litigation brings forward institutional failures and the need for reform, whilst generating policy relevant information and putting points on the agenda of the regulator. It shows where the gaps in regulation are, and even if they are not filled, it encourages self-regulation by corporations, and global issues are approached in a way each jurisdiction can see fit for themselves to solve. The 1990s, as we can see, were part of a first wave of climate litigation cases. This graph shows all the climate litigation cases against corporations and against states within the US, red, and outside of the US, in blue. But if you look at climate change litigation against corporations, the first cases, the first wave was characterized by legal thresholds, such as jurisdiction and standing for victims, causation, the difficulties to prove causation between the acts of the corporation and climate change, and between climate change and harm. The second wave, between 2015 and 2024. In that wave, 230 cases were brought against corporate actors. This ranges from greenwashing up until invoking permits, so all types of green climate cases. The minority of these cases concern claims to mitigate, adapt, or compensate for losses resulting from climate change. Two strong motivations underpin these cases. The first relates to appropriateness to address these issues to corporations. The argument that corporations are the right parties to bear responsibility for climate change. And the second motivation is the effectiveness of the targeted private climate litigation, because successful action will, against a relatively small group of corporations who are responsible for a large percentage of emissions, could generate a considerable, large global impact. This is of importance because the before mentioned influence on regulation, and there are other developments that we can see in these type of cases that strengthen these type of cases. So my second positive note of the day is the second wave is characterized by a broader range of arguments and strategies due to rapidly evolving scientific, discursive, and constitutional context. New developments in climate science and research are delivering new evidence that can strengthen assertions of a causal link between climate change related harm and corporate behavior, which clears the hurdles towards standing and vindication. Attribution science, historical responsibility are all terms you have also heard in the Milieudefensie case, of course. These precedents can have an effect on different types of climate litigation cases. And next to this, we see changes in the discourse of what constitutes responsible climate change behavior, opening the door to new categories of litigants. One part is the regulatory potential of tort law. So courts take up a more active approach towards using tort law as a gateway to also discuss and rule on climate change cases. And the second is the corporate knowledge of and awareness of climate change can also be a factor in how they are, how the standard of care is made up by courts, and how they are how their climate risk management can be judged. And lastly, environmental constitutional context, climate-based claims before courts may find a more receptive judicial hearing because of changes in the way we tend to protect environmental interests and human rights. One example is the international context, of course, the new the General Assembly of the United Nations adopted the right to a clean and healthy environment, but also many right to a healthy environment it's taken up in many constitutions of a lot of countries. So those courts are also tend to have a more positive outlook on environmental and constitutional claims by litigants. If we lay all these characteristics on the Milieudefensie versus Shell case, we can clearly see these developments reassembled in all areas. First of all, the scientific developments. We can see that the court used the historic emissions of Shell to define the current and future duty of care of Shell. And in general, they said corporations that have attributed to historic emissions have a standard of care to also help solve the problems that these emissions caused. And of course, the court rules on scope 1, 2, and 3. They feel they are allowed to rule on those broad range of emissions based on scientific reports by the IPCC. Although it was also said before, scientific consensus is needed to determine the scope 3 obligation in the sense of what is the standard for corporations, what is the amount of reduction percentage. So apparently there's not enough scientific consensus on that element, or there's not enough public law. That's a discussion we can get into. As well as in the, I just said regulation, the courts, the second point, the courts are taking up a more active role. Regulation, the court said, is not exhaustive. EU regulation nor national regulation is exhaustive. So there's a duty of care for corporations and courts can establish that duty of care. So the courts can give a duty of care that's more exhaustive, more extensive than what public regulation has already laid down. And secondly, they state that the control of corporations is also on the supply side, not only on the supplying what people demand, but they also have their own duty in supplying less goods. And the third point, in environmental and constitutional context, well, of course, the court takes into account institutional developments in environmental rights, and they apply human rights accountability indirectly via open norms that Dutch tort law holds. So as well as the first wave of litigation that had an indirect effect on regulation, also the second wave of lawsuits is also set to drive legislative change. This is largely due to, and further to be developed in the area of scientific evidence and attribution. Another area might be appropriate remedies and remedial schemes. When it comes to cases brought by NGOs, which are often injunction cases, we at the Utrecht Center for Accountability and Liability Law, we performed a legal empirical study on perceived fairness of, well, amongst other types of remedies, remedies in private climate change litigation cases. And we took the four most common types of remedies that are allowed for in those or asked for in those cases. And our hypothesis was that, well, the four are the order to draw up a climate transition plan, order to reduce GHG emissions, pay damages to the claimant, the NGO, or the company is at fault, but there are no other actions to be taken ordered by the court. And our hypothesis was that the order to draw up a climate transition plan would be in the league of at fault, but no other actions, because it's, well, a plan. Well, what is a plan? It's not hard law. But surprisingly, it's, well, the first preference of these preferred outcome of these this research. So number 1 and 2 are the order to draw up climate transition plans or to reduce GHG emissions. The outcome of no action required is, well, no surprise, the least favored option. Well, this research is just published, so you can buy the book and read it all. But there's also a blog coming. So, well, is it the next step? Remedies? Where are we going? What would be perceived as fairness against corporations who are, well, have a duty of care? Might be a topic to discuss as well. That's it for now.
Thanks very much. We'll now hand over to Chiara Macchi, who is joining us online.
Hi. Hi, good evening, everyone. And I'm really sorry that I cannot be there in person, but the reason is that I've been teaching until little before the start of this session. Otherwise, I would have been there for sure. So I have listened with much interest to the previous presentations, and so thank you very much for inviting me to this panel. I will just add a few reflections from my perspective. I mostly work on business and human rights. So I would like, first of all, to highlight a couple of points that I think are extremely important, even in this Court of Appeals judgment that, of course, has come to some extent as a disappointment for the claimants, but indeed, from the point of view of corporate accountability, it does contain some extremely important principles. The fact that corporate responsibility for climate change has been confirmed by the court, which indeed confirmed that they are required to take action to reduce their own direct and indirect contribution to climate change. And the fact indeed that the court disagreed with Shell's contention that it could not influence the emissions of its end users, therefore confirming that corporations also bear some degree of responsibility for Scope 3 emissions. Importantly, this judgment also confirms the important standard setting role that certain business and human rights soft law instruments have as authoritative international standards able to color the corporation's duty of care under Dutch law. So confirming this gap filling role that certain international soft law instruments can play when domestic law presents some loopholes. Also, from my perspective, it's really interesting to look at the aspect of parent company liability. In particular, the duty of care of the parent company has been almost uncontroversially affirmed by both courts, I would say. The parent company's duty of care is basically assumed or at least confirmed based on the fact that Shell, as the parent company, adopts and oversees a general climate policy for the whole Shell group, and therefore is both able and under a duty to influence the Shell group's direct and indirect emissions. This is indeed a relatively uncontroversial statement by both the district court and by the Court of Appeal. But if we think of a parent company duty of care litigation in the UK, any British lawyer can confirm that they spend most of their time trying to demonstrate that the parent company's duty of care even exists. And before the Vedanta and Okbabi judgments, actually, some British courts wanted to let's say, required demonstrating the operational control by the parent company over the activities of the subsidiary companies in order to find the existence of such duty of care on the parent company. Now, fortunately, with the Vedanta and Okpabi judgments in the UK, the Supreme Court has accepted that such level of operational control is not required, that the parent company assumes a duty of care even just by its policy setting influence in the corporate group, which is what the Dutch court in the Shell case has also found, and is an important way to some extent circumvent the fixio juris of the corporate veil without formally lifting it. So I think this is a very important finding which can positively reverberate also in other corporate accountability cases. And so this is for what concerns corporate accountability. Of course, I do share some concerns about this judgment. For instance, something that I find a bit contradictory in the court's reasoning is that much importance is placed on the absence of clear scientific standards for sectoral emissions reduction, which led the court to conclude that notwithstanding Shell's obligations under Dutch law, it is not possible to identify a clear standard for emissions reduction. On the other hand, when it comes to other arguments which comes into relevance in this judgment, the court does not show the same level of concern for scientific certainty. For instance, it unconditionally accepts the expert reports presented by Shell in support of its own effectiveness argument, which revolves basically around the market substitution argument, almost implying that the burden of proof to dispel such argument rests on the claimants. Indeed, the argument that Shell will comply with a Scope 3 emissions reduction obligation by reducing its sales and therefore allowing other companies to take over its place in the value chain. This is an argument that is actually debated in the literature. It is criticized, for instance, as explained by Professor Fergus Green of the UCL in a recent blog post. This argument is criticized for failing to consider the expected price increases resulting from a reduction in Shell's sales. So it is technically debatable on the one hand, but the court does not engage with the controversial nature of this argument. On the other hand, I think it is also worryingly close to affirming that there is no point in assigning a specific obligation to an actor that contributes to climate change, since changing that actor's conduct will not in itself mitigate the global climate problem, which goes back a little bit to something that Professor Noel Kemper was saying. In my opinion, in this interpretation of the effectiveness argument, we risk rendering Scope 3 emissions non-justiciable based on the collective global nature of climate change impacts. And this is problematic. And in a recent article, Professor De Jong describes this type of effectiveness argumentation as the product of a cynical worldview that allows one company to continue polluting on the grounds that other companies will do the same. So in my opinion, this argument is particularly problematic. It also links back a little bit to what the court says about Milieudefensie's alleged insufficient interest in the Scope 3 claim. I think we cannot narrowly construe such interest by Milieudefensie as the interest in obtaining the certainty of a reduction in global emissions, an outcome which depends on a variety of factors that are difficult to predict. I think in this case, the court could have and should have recognized that the paramount interest of the claimants is also to obtain clarity about legal principles and obligations that clarify the content of proper social conduct for a carbon major in times of dangerous climate change. Then we can discuss about how difficult it is to identify a specific reduction standard, okay, but I don't think that the contention that Milieudefensie does not have sufficient interest in the Scope 3 reduction claim has merit. If I have a couple of more minutes, I will just briefly refer to the way forward possibly in other jurisdictions. I completely share the view of Professor Nolkemper that we should not overlook the special nature of the Dutch legal system, a monist system with this unwritten duty of care rule that for sure cannot be found in all other legal systems. So we should always be very careful in placing climate change litigation and its strategies within the legal system. Now in France, for instance, corporate due diligence legislation is facilitating climate change litigation against corporations. There is a pending case against Total promoted by Notre Affaire à tous, which revolves around the obligation to include climate change in the plan de vigilance mandated by the French law on the duty of vigilance. And indeed, the claimants argue that Total has failed to include the specific and credible reduction targets in its own plan de vigilance. And as far as I know, I mean, the last news that I've read are that the case will proceed to merits. So we will see what that will bring. Of course, in the EU, we are all a bit anxious at the moment about the fate of the Corporate Sustainability Due Diligence Directive. And of course, under the directive, corporations will be obliged to set their own reduction targets in line with the Paris Agreement's goals. There are no specific targets mandated under the directive, and civil liability provisions under the directive don't apply to Article 22 on the transition plan. However, even under the current text, companies are required to not only adopt but also implement the transition plan, detailing the measures that they are going to adopt, and this might create new grounds for litigation within individual legal systems, also depending a little bit on implementation or on transposition. And also, greenhouse gas emissions might constitute harmful emissions causing measurable environmental degradation, as described in the Annex Part 1 of the directive. So climate change could sort of come back through the window, as we say in Italian, as part of the due diligence obligations established by the directive. Some of the environmental obligations mentioned in Part 2 of the Annex to the Directive, such as the obligation to minimize adverse impacts on biological diversity, might also point to the need for corporations to include climate change considerations into their due diligence processes. And this might once again open the avenue to potential litigation even under the civil liability mechanism. But this remains to be seen. First of all, we need to see whether the directive will actually be implemented and when. Thank you very much. I will leave it at there.
Thanks very much, Kara, and thanks everyone for your very interesting contributions. I'm going to give you all a bit of an opportunity to respond to each other. So I want to open up by asking Sjoukje to respond to Andre's sort of criticisms in a sense of how Milieudefensie brought the case. Obviously hindsight is 2020, but I was wondering if Milieudefensie has learned some lessons from this case that we might bring forward into future cases.
Of course, we always learn, but maybe taking one step back and sharing a little bit about why we started this court case. may also be an answer to some of the criticism that you voiced. When we look at the role of governments in all of this, we shouldn't underestimate the power that Shell has in this world. There are only 4 countries worldwide that emit more than Shell. And if you read the evidence that we submitted, you can clearly also see the role and influence of the fossil fuel industry. Shell is everywhere. Fossil fuel industry is everywhere. If you take any random cabinet of government somewhere, there's probably someone from Shell or the fossil fuel industry in there. So given the fact that Shell is such a big polluter worldwide, that emits so much and has so much power, who is actually going to stop such a large corporation from emitting? It's not going to be an individual government, and certainly not going to be the government in the Netherlands. We have a governance gap. And that's the reason why we decided to take this case to the courts, because we feel the courts are basically the last sort of place where we can go in this very urgent climate crisis. So yes, it would be great if the Dutch government would step in, and we're very happy with the CSDD, which, by the way, also was inspired by or helped by the Shell case. But until that is the case, we need to do these types of litigation. And yeah, it would be great if we wouldn't have to. But governments are failing. We have a governance gap, and that is why we have to take these sorts of measures. Then I think in terms of effectiveness, I think I already replied to that a little bit in my, and then I think in terms of should we have asked for a ban on new oil and gas fields, maybe it could be an interesting one as well. When we launched the court case, the evidence on that wasn't as convincing as it is nowadays. But you can clearly see in our ING case, for example, that we do ask for a ban on ING financing new oil and gas fields. And if you look at our demands in the ING case, we are also asking for, apart from the global emission reduction percentage, we're also including some sectoral emission reduction percentages. We are always listening and trying to improve our litigation strategy, but I think we still very firmly believe in the 45% that we asked for in the first place. Yeah.
And yeah, Andre, you're saying basically it's up to governments to legislate to bring these numbers into being, but in the Netherlands we've seen this right-wing government and in lots of other countries as well. So how do you see that happening going forward?
Yeah, it's difficult to be terribly optimistic about this. Even with the CSDD, we have to see whether that survives the current discussions in Brussels. At the same time, the very fact that it has been so difficult for a state to agree politically what in a particular society should be the path to a transition, and what limitations we should place on Tata Steel or on Shell or on any other corporation. If that's politically and societally so difficult, it should give reason for pause to ask whether a court can then make that determination of what is required. So I was just reading on my way here a piece on the expansion of coal production in China. And intuitively, we say, well, this should be no-go and violates all sorts of standards. But if you see it as a part of a political choice in the energy transition to create energy for those moments when there's no solar, no wind, and so on and so forth, that eventually will be phased out. I mean, these are very difficult societal questions, which may be right, may be wrong. But the question is whether the courts are then well positioned to make those calls. So I'm all in favor of the court identifying a particular, probably narrowly construed obligation, for instance, on new oil and gas fields, and find that a corporation acts unlawfully. But if there's no basis in politics, in societal agreement on where we're going, I think courts should also think twice before articulating. So you use once or twice the terms imposing an obligation. Would be a bit careful with that, because the court can confirm an obligation. They can determine that an obligation has been breached. But I don't think it should be for the courts to impose an obligation that has not been articulated by the political branches. So that's a bit of a dilemma.
Annelies, could you also reflect on the role of the courts? And you mentioned there's a first and a second wave. What do you think is needed for the third wave of climate litigation?
Well, the positive outcome is that the waves are making other waves. So maybe that's the whole sea of climate change litigation. Your question on the role of court, yeah, I was wondering, because I wrote down soft law, the courts confirmed the gap filling role of soft law for gaps in national law, which is, I'm a public international lawyer from, well, study long time ago, but like soft law is not should not be a mechanism to fill up national law, but it still is. Or what is the role now for courts when they deal with, well, gaps in regulation? They have to take some standards somewhere, and soft law is now mentioned as filling the gap, but it's not mentioned. It's not meant to be a gap filler in a sense. It's meant to be, well, what is it? how would you look at me? Yeah, Professor Nolkamp, yeah, or Chiara.
So I'm all in favor of. I mean, there has been quite a few precedents for courts using soft law, quote unquote, for the purpose of interpretation of domestic law, including tort law. So that's all fine if it's part of a wider mix of instruments. If there's nothing at all, and there's only one soft law principle on which states have not been able to agree that this should be hard law, I would be reluctant to decide the case just on the basis of one soft law principle. But in many cases, of course, this is not the reality. In many cases, there's much more. There's a whole complex of norms, hard law, soft law, and then soft law can play a proper role. But it depends a bit on the case and what is on the table.
And Chiara, how do you reflect on the use of soft law in these cases? You, in your case, not from the first case, you mentioned that this is representing a bit of a hardening up of the UN guiding principles of that kind of soft law.
Yeah, it is a soft law. It's used as a interpretation tool, as part of a toolbox, let's say, that the court resorts to in the absence of clear public law standards, although it could be argued that the unwritten standard of care under Dutch law is meant to be interpreted as every duty of care standards, also according to evolving to the evolving legal systems, of which soft law, international soft law in this case, is a component. So of course it is not enough in itself to fill the gaps in public law, and it should not be. But for instance, the UN Guiding Principles on Business and Human Rights that were a hard-won compromise in 2011 have already inspired hard law developments in France, and then by consequence also at the European Union level. And they are being used as the gold standard of corporate conduct to interpret rules of hard law under domestic law, in particular in this case under Dutch law. So they are definitely, soft law in this case does reflect a change in legal landscape in which I mean, I do remember the early debates about business and human rights in which there was an absolute ideological opposition even to the idea that corporations bore any form of responsibility for human rights, let alone climate change. And it's also thanks to evolutions in soft law that nowadays we have a completely different view about that. Having said this, I absolutely agree that this should not be the fig leaf behind which governments hide and avoiding to do their part and adopting binding standards, clear, articulated, detailed binding standards under domestic law. So I absolutely agree that it is time for governments to play that part. In that sense, we cannot just leave the definition of these obligations to litigation.
So I'm going to open up to the people here in person. If someone has a question, we have 2 microphones that are going around. Vesna, at the back. If you could introduce yourself and then ask your question, thanks.
Thank you very much. Yes. So I'm Vesna Lazic. I teach private international law at the Utrecht University, and I'm senior researcher here at the Asser Institute. I have a question in particular for Chiara regarding the directive which you mentioned. And I also think that it could be, and it has overlaps also with climate change litigation. The question is, would that change a lot if, and at the moment when the directive would be implemented? A, and B, do we need something else in addition to that? And also I would like to refer to your kind of remark. Let's see what will happen with the directive. So I just wonder what you really meant to say, because there are also the terms, of course, the final provisions. There are moments for, or time frame for within which they have to be implemented in the national law. There are different frames. So I just was wondering whether there is something else, because I've just seen on the European, on this Appeal blog, that at the 30th of January, the Commission presented some, European Commission presented its compass called First Omnibus Package on Sustainability, in which I also see, I had no time to have a look at that, but also it's mentioned here that it would introduce amendments on this directive. So I just was wondering if you by any chance know anything on this latest development. Thank you.
Shall I reply immediately?
Should we collect one more question and then here at the front?
Yeah, it works. Thank you so much for interesting presentation. My question is mainly, I made some notes. So you mentioned, it's just for the panel, so it's not for a particular person, that Appeal Court referenced also in its decision the role of the fossil fuels investment in the climate change. And my question is, should this issue be raised further, for example, in front of the Supreme Court? Because this was also raised in submission of some states in front of International Court of Justice. So it's quite important. But on the other hand, who will bear the costs if it will be cut in the fossil fuels? Is it the society? Because it also raises economic issues for the people to pay for this transition. Yeah.
And introduce yourself.
Sorry, my name is Dimitro and I'm intern here at Asser Institute.
Thank you. Chiara, would you like to respond to the first question?
Yes, maybe I will quickly reply to the questions on the CS-DDD. Yes, I am concerned for the future of the CS-DDD. First of all, because there are reports that some governments are going cold feet on its implementation. There are reports that the French government, for instance, would like an indefinite deferral of its implementation. It is still politically controversial, even after the hard-won adoption in 2024. It remains controversial. And indeed, there is the proposal for an omnibus package that is a weird proposal in the sense that the rationale, the alleged rationale, is to reduce burden on corporations that would allegedly stem from multiple reporting obligations, for instance, but in fact, the current instruments, the CS-DDD, but also the Corporate Sustainability Reporting Directive or the taxonomy, serve different purposes. the CS-DDD is not about reporting obligations, it's about due diligence. The CS-DDD is, the CSRD is about reporting. The taxonomy is a different type of instrument. So the fear is that the negotiation of an omnibus package might open the door to just watering down what has already been approved, which is why I need to wait and see what will happen. And I am slightly concerned that indeed there could be some changes to the current text of the directive as we know it today. Would the directive change much? That's a very good question, because there are not many precedents. The most similar example that we have is indeed the French law on the duty of vigilance, and I have to say, so far there haven't been many successful cases under that statute. It is a promising avenue in the sense that it allows for checks on the due diligence processes put in place by companies, and this is largely new. In some systems, for instance, in the Italian systems, there were already some forms of due diligence obligations for companies, but limited to, in the Italian case, for instance, limited to a narrow set of very serious violations, whereas the directive would introduce wide-ranging due diligence obligations, in which that's another big question. Could we really read some climate due diligence obligations under the due diligence articles of the directive? My take is that we could, that there is ground to do that if we look at the text of the directive and at its annex. There is ample room for such an interpretation, and that will be absolutely coherent. But of course, there are many questions mark. How will the directive be transposed? How will it be enforced? How will it be interpreted if it comes to litigation by national courts? So it's not a silver bullet, but it is an additional important tool that litigants might, that claimants might have, and that civil society might have.
Thanks, Cara. Would anyone on the panel like to reflect on the CS-DDD question, or any synergies or differences with the state arguments in front of the ICJ?
Yeah, I think it's a fair question that you ask, who should bear the cost of the energy transition. I think one thing that we shouldn't forget is that governments all over the world are still heavily subsidizing fossil fuels. The Dutch government, I mean, I don't have the number already, but I think it was about 40 billion annually that they still subsidize fossil fuels. And even so, green energy is already cheaper. So wouldn't it be great if we actually put all those fossil fuel subsidies where it should go? Because currently society is actually paying the bill for the massive impact that fossil fuel companies have on the world. So I think it's a matter of redirecting the funds. And I think no one necessarily wants fossil fuel energy. Everyone just wants affordable energy. And I think the best way to do that is to put the money where it actually should go.
I'll then read a question from the online audience. So after Shell's decision to relocate its headquarters from the Netherlands to the UK, does this case illustrate a potential backlash effect where multinational corporations strategically relocate to jurisdictions with weaker climate litigation risks?
Well, there actually was a great judgment in the UK 2 weeks ago on Rosebank and Jackdaw, two new oil and gas fields where Shell actually also plays a role. And the court actually said that Scope 3 emissions should be taken into account when governments are deciding to give permits, which is huge. And it actually means it will be harder for oil and gas companies to start new oil and gas fields. We always like to say you can run, but you can't hide. There's opportunities in most jurisdictions, I'd say. So, yeah.
Yeah, yeah, that's an excellent example. And let's not forget that the Netherlands is not the only country that allows for corporations to be brought to the court or to litigate against corporations. For example, in New Zealand, there's a case pending, Smith versus Fonterra, where the court said, well, maybe there we could have a novel tort. Let's hear the claimant out and then see what, law evolves. So it could evolve into a novel tort that allows for litigating against global emitters. Yeah.
Any other questions from the audience? Here.
Hi, I am Eduardo. I am a junior researcher in private international law here in the Astor Institute, and my question is for Anneluz. I wonder if you could expand a bit on the role of, as you mentioned, the regulatory role of tort law in climate change litigation here in Europe, and if you have examples of cases that here in Europe that made use of that. And also, if you could clarify what's the nature of these torts, like are they non-material damages, and who are they owed to? Thank you.
Should we do a quick one more question? And there.
Thanks. I have two questions. May I do the two or just one? The two is fine. Okay, so my first question, well, first, my name is Paula Nieto. I'm a PhD candidate working on climate justice and judicial adjudication. My first question goes to Shoki. What is your understanding of the appeal court assessment regarding the impossibility to apply the precautionary principle to decide the specific percentage of reduction? Because there is no, or according to the court, there was no scientific uncertainty, but uncertainty regarding what standard to apply, because there were like different integrated assessment models. So basically, can we apply a precautionary principle when there is uncertainty regarding integrated assessment models? And the second one is more regarding curiosity of those who know about Dutch civil law. And in regards to the effectiveness argument, so the court basically said that according to Article 3.303, the claimant should prove sufficient interest, and that sufficient interest is should be proved by saying, okay, if we grant the claim, like the situation would change in this way, and if we don't grant the claim, the situation wouldn't change. It's basically like a effectiveness interpretation of the interest to file a claim. And I would just wonder if this is a common practice in Dutch law, because I find it problematic, like to basically have to prove what would happen if we grant the claim and what would happen if we don't grant the claim. It's basically that is the question. Thank you.
Thanks. Anneluz, to respond to the first question? We'll keep going for another 15 minutes or so.
Thank you. The way climate change cases are brought to court has changed, partly due to the role tort law had played in these type of cases, because in the beginning it was the question whether these cases could even be successful in tort because of the causation, the proof of harm, all these typical tort type of proof you have to bring to the court. But you can see through the years that there has been, it has become a debate or a discussion, a dialogue between the courts in what they can do, what they can't do. And you see that very clearly, I think, in the Court of Appeal, Milieudefensie. They say, well, we are here to define the duty of care. We are here to discuss whether the scientific evidence that is brought forward is enough to establish this duty of care. So there's more of a interdisciplinary dialogue between courts, regulators, and what are the courts missing? What can they do? What is their role? So there's more of a dialogue going on. I think that's the point I wanted to bring forth, and that's I think the Court of Appeal should be applauded for it, that they are explicit on what they can and can't do in these type of cases. You asked me if there are examples in Europe of tort law type of cases
actually awards damages.
That award damages. Well, there's the RWE case in Germany against the Peruvian, or the Peruvian farmer against the RWE, the energy supplier in Germany, and the Peruvian farmer asked for 0.47% of his total damages because RWE is damaging 0.47% of the worldwide emissions, greenhouse gas emissions. So that's a type of case that is brought forward, but yeah, will have. I think it just went to the Court of Appeal in Germany. So yeah, we're still waiting on the verdict on that. Yeah.
Andre, do you have any reflections on this?
Now maybe on the question of the standing. So it actually is my take that in many, if not most jurisdictions, certainly also in the International Court of Justice, if a plaintiff seeks a particular remedy, and a finding by the court cannot deliver that particular remedy that is sought, the court generally would decline to offer that remedy, right? There needs to be a connection between the remedy that is sought, the standing, and what the court can offer in terms of a finding. So I don't think this would be a peculiarity of Dutch law. I think it's a general principle of procedural law that in that triangle between standing, the remedy sought, and what a determination by the court can offer. So in that sense, I think the finding by the Court of Appeals makes sense to me.
Well, obviously, I don't agree with that, and I think your question was also on who has the burden of proof in that way as well, right? Should we have shown what it was effective? Well, I think we did show a lot of expert statements as well to show that it would be effective. And both the direct and indirect effects, and the Court of Appeal also didn't take any of the indirects into account in ruling at all. I think in my presentation I already highlighted some of the other effectiveness stuff as well. We published on our website the originating document in cassation as well, in which we go into much more detail on this. If you're interested in that, it's about 155 pages. Some great weekend reading. And then you also asked about the precautionary principle, which I think is also very important as something that the court should have also given more consideration. Of course, when you think of the precautionary principle, it should be better safe than sorry. Yeah, we actually showed in the appeal using case law and treaties that the precautionary principle means that taking measures cannot be postponed until there is scientific certainty. And the court actually did not engage with our contentions on that topic. Maybe a little bit more in the scientific consensus, because we talked about it quite a lot today as well. What we argue is that the court should have looked at both science and then also at legal principles. But even if the court would have just looked at if there would be scientific consensus, yes or no, then looking at the science, you would still see quite a narrow bandwidth of numbers, percentages used in the procedure. The only real outlier there is an expert report by Shell. And it was from an expert from the Sustainable Gas Institute, which is actually founded and funded by Shell, which gave a reduction percentage of about 5%, which is, yeah, a complete outlier if you look at the other reduction percentages mentioned in the court case. And I mean, we still very firmly believe that the court had every reason to go for the 45%. But the court could have also gone for a lower percentage using the bandwidth used in the court case, which is something that was also done in the Urgenda case, for example. Yeah, like I said, we still believe the 45%, plenty of reason for the court to go for that, especially combining science and law. But even just looking at the scientific consensus, there's a very narrow bandwidth apart from the outlier with Shell's expert. Yeah.
Chiara, do you have any reflections on these questions?
Yeah, I have more questions than reflections because I've been thinking about it myself. One thing about the effectiveness principle, what I find a bit problematic is that the court makes this reasoning about Scope 3 emissions, and it reasons that Milieudefensie does not have a sufficient interest in the claim because indeed the court assumes, but to some extent speculates, I would say, that Shell would approach that reduction by reducing sales, and that will give rise in turn to the market substitution. It seems to be, to me, a bit far-fetched, like it seems to be a bit too speculative as an argument to allow for, you know, the exclusion of Milieudefensie's interest in this claim. So to me, that remains a little bit of a question mark. On the specific, well, on the use of the precautionary principle, instead, I'm afraid I agree with the court here that when we talk about scientific uncertainty, we refer to uncertainty about the possible impacts, about the risks. But of course, I will be very interested in reading the argumentation by Milieudefensie on this. On the other hand, I don't even think we need to resort to the precautionary principle when we can resort to the prevention principle in this case. So to me, that doesn't change much let's say, in the direction of the case. But at the same time, I do believe that the scientific uncertainty enshrined in the precautionary principle under international law has to do with uncertainty about the impacts that should not block states from taking cost-effective measures to prevent the impact. But then again, I will be happy to read the Milieudefensie's stance on this.
Further questions from the floor? Here.
I have a very small question about the Dutch law part, actually, because I was also confused at the first instance, but also at the appeal, because the unwritten standard of duty of care comes from tort, which is from Article 6162. But then when I read your claims, it sounds more of an injunction to me and not a damage claim. And I was a bit surprised if this was possible for the judge, for the court, to combine these two injunctions and damages and then come up to a conclusion, or is it more of the way you initiated the claim in the first place? Thank you.
Introduce yourself.
I'm a PhD researcher at Erasmus University. Yeah, I'm okay.
And another question.
Hi, I'm Hendrik. I'm also intern at Vaasa Institute, and I have a question for Professor Neukemper. So you stressed the point that it's really difficult, or might be interesting in the future, on how the court will identify public obligations in EU law, international law. And then you said that yeah, they won't impose implications. They will identify them, because in legal theory, judgments are only declaratory of rights and obligations, not creative of new ones. But I think that might be wrong in this case, because considering the evolution of fact in climate change, and also recent litigation, be it in Klimaseniorinnen, other cases, or maybe also the upcoming to advisory opinions, yeah, evaluative interpretation plays a huge role in this issue, I think, and I see a huge opportunity there to maybe also step outside of existing obligations and maybe to actually impose obligations. What's your point on this? Do you think the Dutch court could go that way?
Thanks. Answer the first question.
Yeah, thank you. Article 3296 of the Dutch Civil Code states that a court can order a party to do its duty. It's rechtsplicht in Dutch. And this duty can be found by either law or the standard of care as written down in 6162. So if you have to establish what the duty of a certain party is, and I translate duty in a wrong way because it's not exactly the same as 6162, as the duty of care, but it's rechtsplicht, so what you ought to do. To find this, what you ought to do, you can have a look at 6162 of the Dutch Civil Code, which amongst others states the standard of care. So it's either, but it can also flow from law or from contract.
So this is a good question. So indeed, there's a thin line always between the interpretation of an existing obligation and the identification of a new one. So the ICJ in the advisory proceedings certainly will not say that they will articulate a new obligation. So they probably will interpret the existing no harm rule, perhaps in a new shape. And they will simply say that they identify that obligation in customary international law. In Klimaatsenioringen, the court implied that they interpreted existing obligations under the European Convention, positive obligations. If you would press them, I do not think they would admit they would create new obligations. They simply interpreted obligations on the European Convention in a particular setting. And that will also hold in domestic law. So I may have been a bit too strict in saying that the court can never find something new. There always will be, by interpreting the existing obligation, space to do something new in a new constellation of facts and law. And in the examples that we discussed, certainly for scope 3 emissions, expansion to new oil and gas fields where the law is not so clear, whether you can read that, for instance, in the positive obligations under the European Convention, that will be a matter of interpretation and indeed evaluative interpretation that might border on creating something new. And the question is always, where do you put the threshold? At what point does the court go too far in its interpretation, and where does it actually create new law which would exceed its boundary? So it's a gray and very relevant area.
Any last urgent question before we finish up? In that case, I'd like to thank everyone for a very interesting and lively discussion that I'm sure has given everyone some food for thought. So please join me in thanking our speakers, Andre, Sjoukje, Annelies, and Chiara. And I would also like to thank Antoine Duval, Eduardo Silva, Freitas, Vesna Lasic, as well as Romina Rusin and Dimitri Cerneja, interns, and the events and communications team at ASER Institute and the Netherlands Network for Human Rights Research for their help and support in organizing this event. So I'd now like to invite those in person to continue the discussion over drinks, and everyone online, I wish you a good evening. Thank you.